Hey now, this is a certified hood classic.
Bueller.
All rise. Order is in court. We're late. I apologize. That's my fault. You can blame me. Love this, by the way. So you've got a nice new flag behind you.
Oh, yes. The T-Royd detention scent.
Love it. Yeah, just sense.
The scent.
Great. Oh, look, fourth time.
Of course, Creed, it is Monday, so why not go in and check out and see what everybody did with their weekend that put them in jail.
Let's do it. Let's jump into it. Hope everybody had a great weekend. Welcome back.
Marcus D'Anthony Adams Jones.
Thank you, Mr. Adams Jones. Sir, Magistrate Chartea, you're here on 2 criminal matters. First case is 8224-711-4201. That charge is domestic violence.
Ooh.
Next case is 82-24711. Excuse me. Let me repeat this.
Water? Water? Judge, water?
Case number is 82-24711-73601. The charge is police officer assault and resisting obstructing.
Sorry, you guys.
Officer Reagan, go ahead. Go ahead.
Judge, good morning, man. Please support Philip Reagan, 57156 on behalf of Mr. Adams Jones, waive formal reading stand mute and advising his rights, Judge.
Adam Pac-Man Jones?
Enter plea of not guilty on the misdemeanor matter. Court date is June 20th, 2024. It is pre-trial, 9 o'clock at the Hamtramck District Courthouse. On the felony matter, court dates are June 20th, 2024. Probable cause conference followed by preliminary examination, June 27th, 2024. Both matters 9 o'clock at the Hamtramck District Courthouse. Okay, Mr. Adams Moore, the misdemeanor, sir, while this case is pending, you're not to have any contact with Jayla Lene Williams.
J-Lo?
When I say no contact, sir, that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons, and you're not to go to the Selfridge residence in Hamtramck. Do you understand those bond conditions?
Yes, ma'am.
On the felony matter, there's no assault or combative behavior on your part. Do you understand that?
I couldn't understand exactly what you said. Say that one more time.
On the felony matter, there's no assaultive or combative behavior on your part.
Oh, thank you.
Do you understand that?
Yes, ma'am.
All right. Detective, go ahead and tell me information about Mr. Adams Jones, assaultive or pending cases, prior cases.
Your Honor, there's
Detective Tilapia.
no adjudicated history for Mr. Adams Jones.
Gary.
I was advised by the victim that there is a history of domestic violence, but all the cases were closed previously. He is not on probation or parole, and no violent warrants or anything of that matter, Your Honor.
Okay. All right, Counsel Reagan, go ahead, Esteban, please.
I was going to echo same information as Detective Judge. He and Miss Williams have 3 kids together, but I informed him he's not to have any contact. He said he's going to go to design, so there won't be any contact. I would ask the court for personal bond, just with the condition, and I think he understands, as the court has already stated, it's not to go back to the press. So I am requesting the personal bond, Judge, with the condition, Your Honor.
Okay. Well, Mr. Adam Jones, just reading the allegations in the investigator's report, allegedly start off with some sort of violence against the complainant, and then allegedly there's violence against a police officer or police officers.
Wow.
I'm surprised. Don't say anything, sir. I'm surprised that nobody asked for some sort of monetary bond. So it gives me the impression that maybe this was an isolated incident in terms of your behavior.
Thank you.
Other outside of the complainant, your behavior with police and other third parties. So what I'm gonna do, sir, is I'm gonna give you a $50,000 personal bond on each case.
50K
Nobody has to pay any money for you to get out of
on
jail.
each case, 50K.
Yeah.
Yes, sir. Okay. Ball's in your court. You break any of the bond violations, bond conditions, you don't go to court. Next time you're gonna be looking at a monetary bond, you better bring your toothbrush, because you may be sitting in jail for a while. Do you understand that?
Pack a lunch, son.
Yes, ma'am.
Okay. Anything else in reference to Mr. Adams Jones?
No, that's it, Your Honor. Thank you.
Well, he's been busy.
Council Reagan?
Is that the periodic table behind the detective?
Okay.
Couldn't tell. Look at these two studs.
All right, gentlemen, please stand up.
Too fast of a cut.
Stand up.
That appears to be two mugs, by the way, over here. Pink one and a white one.
Alright, so I'll come right here so that she can hear.
One's for water, one's for
The gentleman with the white shirt, what's your name, sir?
Phil Verone.
Is your name Hunter Thomas Jackson, sir?
Yes,
Hunter.
yes.
Uh-huh.
Oh,
And the
he looks
gentleman
like
who's
a-
standing to your right, what's your name, sir?
Nicholas Jeffrey Umstead, Your Honor.
Thank you. All right, Mr. Umstead, you're defendant 2 in this case. Mr. Jackson, you're defendant 1 in this case. Case number is 82.
Mike Devine.
711-749-01 and 02. Gentlemen, I'm Magistrate Chartea. You have an attorney. Go ahead, counsel.
Your Honor, parade on behalf of Mr. Umstead and Mr. Jackson, as to both gentlemen waive the formal reading stand mute, they've been advised of the arrest, Judge.
Thank you. I'm an entering plea of not guilty. Court dates are June 20th, 2024. It is a probable cause conference followed by preliminary examination, June 27th, 2024. Both matters 9 o'clock at the Riverview District Courthouse. All right, let's see. Some bond conditions for both of you. Mr. Jackson and Mr. Umstead. 1, you're not to have contact with complainant Shirley Jackson. That means no person.
Shirley must be kidding.
No contact with third parties, no phone calls, no emails, no text.
I am
messaging.
kidding, and don't call
Neither
me
of you are
Shirley.
to possess any firearms or any other dangerous weapons, and neither of you to go to the Park Ridge Drive residence. Do you understand the bond conditions, Mr. Jackson?
Yes, I do.
Do you understand the bond conditions, Mr. Umstead?
Yes, Your Honor.
Detective McDonald, can you tell me priors, pending cases in reference to Mr. Jackson?
Mr. Jackson has some outstanding, well, not outstanding, but prior conditions in Florida. The CCH is a little hard to understand.
Florida.
But as I understand,
Makes sense.
Mr. Jackson did have a prior for a violent assault down in Florida. But as far as I know, he's no longer on probation for that incident. I would like to say, though, Mr. Jackson is also involved in another incident involving the same victim and his mother. And Miss Shirley Jackson is the victim in that incident. And he was in the home at the time the incident occurred. And Miss Shirley Jackson also has a concern for her own safety when it does come to Hunter.
I hate that name. God, I hate that name.
Okay, hold on a second. So let me get this straight. He's in trouble for assaulting Shirley Jackson, and he's also a witness in the assaulting of Miss Shirley Jackson.
I think you're right.
Okay, just want to make sure I cleared that up.
Yeah, he's got something going there. Creed's got one too, but not quite as pronounced as his.
Detective, my understanding, Detective, you said that Mr. Jackson, is there an ongoing matter between Ms. Jackson and the defendant's father?
Yes, there is an assault with intent to murder case involving his father and the same victim.
Okay, that pending?
Yes.
So his dad assaulted her too?
Bond on that?
Was it all three of them that I don't know.
So dad assaulted Shirley Jackson.
Mhm.
He was a witness of the assaulting of Shirley Jackson previously, and now he's also assaulted Shirley Jackson.
I believe you are correct.
We're going deep and we're going hard.
Huh?
Shirley, you can't be serious. I'm serious. And don't call me Shirley.
Is that actual audio from the case? Or
Sounds like it.
Remanded. He's in Wayne County jail currently.
Okay. Three
So
man
Dad's in
status.
jail.
Okay. Tell me about Mr. Umstead.
Mr. Umstead, CCH includes retail fraud, third degree. That was in 2014. He pled guilty. Possession of marijuana, he pled guilty in 2015 and 2021. Receiving and concealing property less than $200. Possessing a weapon. It was listed as switchblade. Motor vehicle tampering, and
Switchblade.
possession of controlled
Get white.
substance. Cocaine. He pled guilty to all of those back in 2021. As far as any other pending matters, I'm not.
Okay. In
I
reference,
have. We will do that sometime. I'll go through my all my shit. I added a new thing that I'll show you later that I got
The
yesterday.
series. I like the series.
I like it series too.
I want to see Creed just like.
Well, you want
know.
backstories. Why do you
Yeah.
have this? Why is
Yeah,
this
that's what I'm
there?
saying. I like the series idea of Creed's like, hi,
Yeah.
welcome. There's a lot of good like fast cuts,
Right.
flashbacks.
Good. I'll get an editor from Fiverr. And then we'll call Bishop and ask him where all the really cool shit is. Like the 4-foot tall champagne bottle and
Landfill.
lots of. Don't say that.
to Mr. Umstead, there's no assaultive convictions or pending cases. Is that correct?
Not to my knowledge, Your Honor.
Surely you can't be serious.
I am serious. And don't call me Shirley.
All right, guys, in the front round, right one.
Got it right that
Against
time,
Umstead,
baby.
No assaults.
You done well.
27, he's working every day. Lives with his stepdad, Your Honor, in the Metro Detroit area. For him, Mr. Umstead, I'm asking for personal bond. Again, we're at arraignment, Judge. Obviously, bond has to be set. I don't think he's a flight risk per se. He does have some prior non-assaultive situations, but I would ask for personal. For Mr. Jackson, Judge, I would just ask for some type of nominal bond, Judge. He's 26. You did hear he does have a current pending case where there's a remand. Obviously no contact, as the court is going to say, but I am asking for some type of nominal monetary bond for Mr. Jackson.
Thank you. In reference to Mr. Umstead, everything that the
I was sitting here earlier today and I was thinking to myself, Mikey, we can wait for Creed, or we can go ahead and start the show without Creed. I'll play the videos. We're not about Creed frames or anything stopping us. But then I said, you know what, Mikey? Don't be a dumbass. There won't be any Creed frames. That's right. People say, Mikey, 50K is going to change you, Daddy. Baby, we ain't changing. For better or worse, we're in this together. Now, for the people that hate watching us during the talking portions of our show, you really don't hate this. But after this is over at 2:30, I would like to ask you to cordially go over and watch. We have more Detroit Court, but without us. You're going to just top tier case and some other cases that we won't cover here during this session. So make sure you check those out. 2:30 Eastern over on We Got a Case. Court Watch affiliate.
Sorry about that. No, it's just not even working.
No. It's just making decisions. It's making life decisions. The girl from Iponema.
Has a current pending AWIM case, correct?
right.
That's what I'm.
Or his father does.
His daddy.
Present at the incident.
Stepdaddy, I believe.
He was there when Daddy was doing it.
So let's get this straight, detective. Okay. There is no pending case against Mr. Jackson.
Nope.
No, not as a defendant, no.
Okay.
That changes,
But
Judge.
he's
I'm
list-
asking for personal bond now.
Okay, that changes things. That does. Okay, I still understand what you're asking for. However, okay, he is, just so I understand, detective, He's a witness in that AWIM case.
Correct.
Is there any type of order to keep him separate from or not approaching the complainant Shirley Jackson?
No order currently. Like I
There
said,
is now, though.
I had a concern with him in that case that he instigated the situation. We did not.
Oh boy. Sometimes this doesn't pay to get out of bed. You know that? It's one of them days, Daddy. One of them days that Mikey wishes he hadn't got out of bed. Been working hard all day, and here we are now, enjoying all this fantasticness called Creed Frames. Creed Frames. More him get this playing before he can get back on, and that way we don't deal with this anymore today, kids. No more. No more, I say. Boy. All right. Before he can get back, I'll have it up. It's cute the first time, you know.
Marcus D'Anthony Adams Jones.
Thank you, Mr. Adams. He is, just so I understand, Detective, he's a witness in that AWIM case.
Correct.
Is there any type of order to keep him separate from or not approaching the complainant Shirley Jackson?
No order currently. Like I said, I had a concern with him in that case that he instigated the situation. We did not charge him with anything. The family also has concerns with him, and I wasn't able to reach it in the swear-in, but there's been evidence that he has tried to break into the house prior to his apprehension in this case. That report was included. So we're not sure how many times he actually had gone into the house and what all he had actually taken.
Well,
so my only concern.
Go ahead.
My only concern, Your Honor, would be a substantial cash bond and at the very least a GPS tether to ensure that he does not go back to that location, because we also advised them to stay out of trouble or we would be monitoring the situation with his father's case, and that clearly did not dissuade him this time.
Okay.
You missed anything.
Reagan, you want to go add as to your bond recommendation or bond?
That changes my recommendation. I'm asking.
Bless you,
personal
whoever that was.
Judge, I don't know of the Florida information. I don't know what's happening with that necessarily, but in terms of him being a witness in that case, that's one thing. No contact. Obviously, the court is going to want to make sure that happens. Whatever other condition the court wishes to set.
Yeah, Kieran. So the father has a case too, because apparently he allegedly put hands on Shirley as well, right?
Yeah. And then Beavis over here, he was the witness to it all. Then he decides, what's good for dad is good for me. I'll go and rough her up a little bit too. Maybe she'll drop the charges on old Pops, and that didn't work out either.
Hey, baby.
We understand, Judge, if there was a tether in place to make sure there was no contact, but I would ask for a personal bond at this time.
Well, in this particular matter, not knowing what Florida is, he is a witness in another case. However, it does not change from what I heard and allegations in the investigator's report that the complainant is afraid of him.
But yeah.
So we're not going to do $50,000 cash. We are going to do $50,000, 10%. He is going to get a GPS tether, house arrest. That concludes the arraignment on Mr. Jackson and Mr. Umstead.
Thank you.
Thank you.
All right, Umstead. Take care. Arrivederci.
Yes, Your Honor.
TNT.
My understanding, are you ready for with Lincoln Park?
Yes, Your Honor.
Detective Stafford? Lincoln Park, can you hear me?
Yes, ma'am.
Okay. Detective, can you have Ms. Morales and Ms. Corf both?
I'm trying to figure out why that guy's got a sticker on his glasses lenses.
To tell him, isn't that like a plus 200 or something?
I think you just take that off. I'm gonna go get the co-defendant. I'm gonna do them at the same time. Why not? Yeah, she was hiding some big ones too. Yeah, you didn't see it, but them things were hang low, sweet chariot.
Cause I'm TNT.
She's holding them. Them things must be cold.
She's hiding her
There they are.
great t-shirt. Wow. Yeah, they're
Told you.
misshapen a little bit too.
Those aren't misshapen. Those are what you call all natural, like Creed Bratton would
One's,
say.
one's a little lower than the other.
Oh, here comes the other cold one.
Thank you, I appreciate it. The young lady with the white shirt, please say your full name.
Alonso Morales.
Thank you. And the young lady in the black shirt, please say your name.
Jessie Marie Corf.
Thank you. Ms. Morales, this is Magistrate Charfea. You're defendant 1 in this case. Ms. Corf, you are defendant 2 in this case. Case number is 8224711759-01 and -02. You both have an attorney. Go ahead, Counsel Reagan.
Reagan, on behalf of Ms. Morales and Ms. Corf, as to both ladies, waive the formal reading, stand mute, and advise of the rights, Judge.
Thank you. I'm going to enter a plea of not guilty. Ladies, you have the both same court dates, June 18, 2024, probable cause conference, followed by preliminary examination, June 25th, 2024. Both matters, 9 o'clock at the Lincoln Park District Courthouse. You understand those dates, Ms. Morales?
Yes, ma'am.
Voss, what a beautiful
You
reference.
understand the dates, Ms. Corf?
Yes.
So cold
Okay.
in the
All right,
deep.
ladies, so you understand you have some bond conditions. One is that you're not to have any contact with the complainant in this matter, Lori Mulligan. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Either of you are not to possess any firearms or any other dangerous weapons. Also, you're not to go to the Myers, that's on Dix, as well as any other Myers.
Myers on Dix is the best.
Pending. Do you understand that, Ms. Morales?
Morales.
Do you understand that, Ms. Corf?
Yes, Your Honor.
Yeah, Detective, can you tell me in reference to Ms. Morales, what kind of pending matter she has? Any of assaultive?
Not that I'm aware of, ma'am. She does have a failure to appear for retail fraud out of the city of Southgate.
And just like that, the cat cuts Creed off. I mean, he's 3 for 3 today, kids. I mean, what more can we ask for?
That wasn't a Creed frame. That was a
Yeah,
goddamn
we know. We already talked about it.
walking across to Jesus Christ, Colton.
3 for 3.
Well, that one wasn't a Creed frame. That was Colton.
Okay.
Colty frame.
That doesn't count.
And,
The cat stepped on everything.
go ahead.
It really was. He
Ms. Corf has
Knocked us
two
off.
failure to appears out of Southgate for civil matters, and she also has a Lincoln Park warrant with us.
And what is the Lincoln Park case? Is that a misdemeanor or felony?
It was a misdemeanor.
And what kind of misdemeanor is this? A traffic?
Traffic, ma'am.
Thank you. Okay. Go ahead, Counsel Reagan.
Judge, I'm gonna be requesting personal bond for both young ladies.
Sweet young ladies.
The officers already, detectives already said what the history is. Ms. Morales is in the process of filing for disability, Judge. She does have some health issues.
Oh no.
Does have an older child. Ms. Corf, I'm sorry. Judge is working at the Eagle downtown. No other history out other than what the detective has stated. I'm asking for personal bond for both ladies. Obviously, no contact with the location or individuals. Obviously, they're charged separately with 2 separate situations. Ms. Corf charged with an accessory after the fact. Ms. Morales charged with the attempt larceny and the unarmed robbery. But I am asking for personal for both young ladies, Judge.
Thank you. Court has heard the representations of Counsel Reagan, has had an opportunity to read the allegations in the investigative report. We have both defendants.
All three people are built about the same.
They are not in their 60s. The complainant is in her mid-60s. Okay. And while there's
Kaylee, thank you.
information or allegations in the investigative report that Ms. Corf may or may not have known a little bit further information. Okay, the same thing with Ms. Morales, what Ms. Corf knew or did not know. Okay, these are the charges that we have. All right, so with Ms. Morales, okay, she's not going to get a personal bond. Using clear and convincing evidence standard, it's going to be a monetary bond. Court does believe that Ms. Morales, as well as Ms. Croft, both are a danger to the community.
Oh, wow.
In this particular matter, Ms. Morales, she's going to get a $50,000 cash, no surety, no 10%. Ms. Corf, on the other hand, is going to get a $50,000 10% bond.
The other lady's effed in the
And
head.
both of them.
Oh, she's going to faint.
She going to fall over?
And do they both work, counsel?
Judge, Ms. Morales is not working.
They're working on disability.
Corf is working, but I'm sorry, Judge, I may have missed something. You said 50,000 cash and 50,000 10.
That is correct.
There, is this based on you reading the investigative report? I understand the flight risk aspect based on the warrants in the past, but you said they're a danger based on the allegations.
I do believe that they are a danger, okay, in this matter. It's questionable as to Ms. Croft, how much she knew, okay, and whether she was a direct participant or an indirect participant. Okay, but I'm going with what I'm seeing here, okay, and is after the fact, Ms. Croft, Corf, I apologize. Thank you, Ms. Corf, Korff, okay. I do believe that both of them are a danger. They also have issues, but while I'm taking it into consideration, it's not as much for the flight risk, more of the danger. So for Ms. Morales, $50,000 cash, GPS tether home arrest. Ms. Corf, okay, $50,000, 10%.
What does that mean, ma'am?
I'll tell you in a moment.
What's that
In a
mean?
moment, 10%. And Counsel Reagan, you said that she works?
Yes, she does work. She did work. I'm hoping she didn't lose her job now. She's been off work.
Yeah, I could have got out.
So she's working
right.
with people.
Okay, well,
That's an
she's
eagle?
gonna get a GPS tether work only.
It's a
And
job?
so for both ladies, Ms.
She gets
Morales,
a grocery store?
$50,000 cash. That means somebody has to post the equivalent of $50,000 cash for you to get out of jail. Okay, not only that, if somebody makes bond, you have to be placed on a GPS tether, which would be like an ankle bracelet, and you would be restricted to home confinement. Do you understand that, Ms. Morales?
Yes, ma'am.
Okay, Ms. Corf, okay, your bond is $50,000, 10%. Your, if bond is made, which is $5,000, okay, you are also placed on a GPS tether. However, I would allow you to work only for that tether. Do you understand that, ma'am?
Yes, ma'am. I can't come up with that.
Okay, well, however, I'm gonna let
Sorry.
you know both that whoever your attorney is, whether it's the same attorney or a different attorney, that attorney does have the opportunity to go to the judge in Lincoln Park District Court to petition a modification of your bond amount and bond conditions.
Walter, oh, they
You
got her a
understand
chair.
that?
Needs a chair.
Yeah, I can't get no.
Good for her.
Okay, do you understand that, Ms. Corf?
No.
She's going through with the bit.
You said no,
She
ma'am?
is.
She's working
I
it.
don't know what that means, ma'am.
Okay, that's all right. Let me say this. Bond is $50,000, 10%. $5,000 has to be paid or some equivalent to $5,000. Plus there's a GPS tether that would be placed. It's like an ankle bracelet But however, instead of you being restricted at home,
Yes,
okay,
very beautiful.
you're allowed to go to work. And when I
Okay, but-
say those bonds, this applies to you, Ms. Corf and Ms. Morales, is that whoever your attorney is does have the opportunity to go in front of the judge in Lincoln Park District Court and petition for a modification of your bond, change it to personal bond, reduce it to anything less than $50,000, 10%, to change the bond conditions, whether it's GPS tether or no GPS tether. So the judge in Lincoln Park District Court, whoever the judge is, okay, can
They
have a
both are.
hearing and can address the issue of bond amount and bond conditions.
Okay.
That would be up to your attorney. Do you understand that, Ms. Corf?
Yeah.
Okay. Do you understand that, Ms. Morales?
Yes, ma'am.
Okay, now I'm gonna let Counsel Reagan. Counsel, do you want to place anything else on the record?
Judge, I don't know. Maybe I'm missing it, Your Honor. I hear what the court is saying. You don't have much respect for this court, but I know this
Nothing but love.
we're not at the sentencing aspect. We're not at the guilt or innocence aspect. We're just simply at bond. And I think it's a lesser included situation that you could use based on the fact Ms. Morales
Look at him crying.
prior assault of history. She's 50 years old, never been accused as a retail fraud warrant, but never been accused of any assaulted type history.
Quick poll in the chat. Is this 100%? Oh, is she taking a dump? Or, oh no, I just paused it perfect.
Oh my God.
Is this 100% acting, or did they walk in there thinking that it ain't gonna be nothing like this? Because listen, this could be a big dose of reality for somebody walking in that thinks they're just gonna get PR bonded out. Ain't no big deal. And then all of a sudden you're throwing around 50K, and I guarantee you they're not listening to how she just broke that down about the 5K. But
Yeah, the one gets that only needs 5K, but that one needs 50 grand.
right, yeah, the
Maybe.
one's completely after.
The one that can't stop standing up and sitting down and tumbling
Yeah.
and stumbling. Yeah, this is all acting. These are all, they knew what they were doing when they got, coming in here, and they should know better. And I'm sure they are upset. I mean, they're gonna miss dinner. So I mean, yes. She should puke. If she puked, I would let her out.
You'll take it. You let her out on a PR.
Blah, everywhere.
I'm saying kind of punishment thing, but I guess I'm just a little confused. And I think, Judge, if it was a ongoing situation,
She's ugly crying.
and maybe it's something I don't know. I don't have privy to, Your Honor, and I apologize. But I just think there's a less inclusive way to say for the tether, maybe house arrest, but a personal bond. I don't think cash bond of that magnitude, I think, is excessive. That's all.
Thank you, counsel.
Thank you,
Bond
Your
stay as it is. Thank you, Lincoln Park.
Thank you, Your Honor.
Nice try, counsel.
Good try.
Thanks. God bless.
Calling case number 240-576-2601. People in Michigan versus Cinnamon Rimaid. Ma'am, state your name.
Cinnamon.
Cinnamon Rimaid.
It's quite
All
a
right,
name.
appearances, please.
Deanna Livingston, behalf of the people, P69721, Your Honor.
And Your Honor, Mark Lakin, P41147.
Straight off the golf course.
Rig Maiden. Your Honor, I'm making a limited appearance. The family is scampering to retain me today, so I'm going to trust that that's going to happen.
Their check cleared, Your Honor.
Okay. Waive formal reading, stand mute, Mr. Lakin.
We do. I have a copy of the charges. Yes, we waive formal reading. We'll stand mute.
All right, court, a not guilty plea on behalf
I went against my best judgment. We were at the discount grocery store yesterday or 2 days ago, and they had Skyline chili in a can.
Mm.
And I bought 3 cans because it was only 75 cents. And they're just dented cans.
Mm.
And it's worth it even with the cinnamon that they put in it, even though they swear up and down that it's not. But
Did you eat it?
Not yet.
Oh, I need a food review later.
Are you asking for a remand, Ms. Livingston?
I am, Your Honor.
Okay, proceed with your argument, please.
Your Honor, given the seriousness of these charges, given the number of the victims, given the danger of the community, and given the high likelihood of conviction in this case, the people are asking for a remand. As I'm sure Your Honor is aware, as stated in the investigator's report, this defendant decided that she wanted to make her ex-boyfriend, quote, feel her pain, which she was able to do on the 3rd of June. She deliberated for at least 2 to 3 hours beforehand. She then decided she was going to go to a gas station, purchase 75 cents worth of gas, drive over to the location,
handful,
approach the home with the gas in her hand. Upon getting onto the porch, she then poured that gasoline onto a couch that was
not a couch.
Porch. She did this with knowledge that the uncle of her ex-boyfriend was in that home. Previously turned her away a half hour ago. She did this with knowledge that the uncle's fiance was in the house.
Dude, you light a couch on fire with just a little bit of gas and everything's going. You dump a bunch of gas on there and light a couch on fire on a porch.
Couch will go up quick and burn hot, even though it's on the front porch. I mean, it's got to be near the front door. You've just cut off one of the exits of the home. Wow, that's evil.
She did this with knowledge that the ex-boyfriend's mother, who is paralyzed on the left side of her body and has limited mobility, was in that house.
Oh,
And
no.
then she set that couch on fire. She then left the home, but she did not leave the location. She sat in her car and picked up her phone. She did not call 911. Instead, as the house is burning with the people inside, she texted her ex-boyfriend and said, your house is on fire.
So remember when Tiana here, I believe that's how you say her name. Remember when she said because of the high probability of getting convicted?
Ooh,
she was right.
I'm like, she wants them remanded.
This sounds very bad, especially if you're sitting there watching it burn down after you've done that. And, you go,
And then texting your boyfriend like, hey, your house is on fire.
Oh my God. Kirna, thank you.
She then left the location and went to McDonald's. And then it's alleged that she, for her own words, purchased cocaine.
At McDonald's?
The consequences of
How do
her
you
actions that night.
Is that in the drive-through? How do you get cocaine? Cocaine?
Maybe the dealer hangs out at McDonald's. I mean, I don't know. That's
cocaine down to the ground. Cocaine
caused the fiance to have to jump out of a second-story window, to not have any more smoke inhalation, which upon landing on the ground, she fractured her ankle. The uncle had to flee the home to not suffer any more smoke inhalation, but not before he had to make the decision to leave his paralyzed sister in the home.
Oh, no.
The victim in this case, who I've already stated her limited mobility, was able to climb out of her room and made it to the stairway second floor landing, where her body was found burned.
Oh my God.
She killed her ex's mother, burned down the house, injured her uncle, his uncle, and his uncle's fiance.
Oh, wow.
Killed, unalived, whatever you want to call it. Jeez. That is.
Numerous burns over her body and smoke inhalation.
Oh, and what a way to go. Like that.
Trying to crawl your way out of the house. Remember, half her body was paralyzed.
Yeah.
Did the Durrell family and Miss Johnson suffer? The house next door also caught on fire.
Oh, no.
It was that bad. Therefore, Judge, I believe the only appropriate bond in this case is a remand. And I would also like to note to Your Honor that I was just made aware she also has a prior that is not listed on the warrant for uttering and publishing from 2006 out of the Sixth Circuit, which she was given height of probation for, but apparently it appears that was revoked as well. So I'm asking Your Honor to remand us the defendant for the reasons that I have stated thus far.
Thank you, Ms. Livingston. Mr. Lakin?
Let me just make an inquiry as to what year the Oakland County case was.
2016.
All right, so it's 8 years ago. She would have been 23 years old at the time.
Jamie D, thank you for the $2.
I like this barely trying attorney here that the family's scrambling to pay.
Yeah. Again, you made the joke about him. He was probably out on a golf course when he got
Yeah.
the call and got
He had to come running into court. I like that he's coming in with the when was that? Oh wow, all the way back in 2016. She was only like 24 years old, practically a child. Now she's killed somebody.
Jesus Christ.
Your Honor, obviously the prosecution has more knowledge of the facts that they present today. I have not had the benefit of.
Oh no, he didn't even know. He didn't even.
No, he didn't even know she'd been arrested before.
Oh no, he didn't even know most of the cases in this, or most of the facts in this case.
I've looked over briefly at the case.
Can you sit here and just like bow out and say, bye bye?
We were just cooking out back. Had to take the apron off. Your Honor.
Oh my God, Mikey Mike.
Hello, sir.
Reading a police report yet. I don't think that any actions were meant to harm anyone but property.
What?
And unfortunately, there were some deadly consequences here. I know her as someone who has no criminal record, which she does not have. If she got, so that's our position. Our position is that she was interviewed by the police and cooperated in every way possible to her benefit. This investigation is basically, they know what happened here simply because she completely cooperated with the investigation. So she is entitled to some sort of a bond without a prior record. Obviously, something has happened here that went badly. So, but I don't believe that she intentionally meant to hurt anyone, except some property. So,
I meant to hurt property. Yeah,
that's our position. We'd ask you to give her a bond.
Okay,
He just did it. I didn't think he was gonna. For a second there, I thought there was some word salad of him trying to get something together, but he really did just ask for a PR bond.
I mean, he's a. I'm not saying he's a bad attorney. This attorney, I mean, he had no idea. I don't even think he knew what he was walking into.
No,
did he read anything?
I don't think so.
She's just trying to. She hated that couch, Your Honor.
That's what. Correct me if I'm wrong. He's trying to go with. Well, we just try to kind of burn the porch a little bit and show.
Yeah, we're just trying to damage some property. That's
right.
All.
Well, it didn't work out that way.
Argument as to bond under M. People requesting under Court Rule 6.106 a remand, which is allowed based if their defendant's guilt is evident or the presumption is great. And Ms. Livingston presents an argument that the presumption of guilt is great in this matter. Accordingly, and given the egregious nature of this offense, the court will remand Ms. Rimaid into custody of Wayne County Jail while this case is pending. Probable cause June 14th in front of Judge King. Preliminary examination June 20th, 1:45 p.m. Both in front of Judge King.
Thank you, Your Honor.
Good luck.
Thank you.
Good luck, King.
Step aside, Ms. Rimaid.
Wow, that's
denied.
That's horrid.
That one really took a turn. Jesus Christ! I bet she didn't really mean to do quite that, but still,
I mean, she saw it was getting out of control and the fire was burning out of control. But instead of calling fire department, she gets in her car and texts her ex and says, "Hey, your house is on fire." Goes to McDonald's and purchases the cocaine.
Yeah. Whew. All right. Well, that's that. Sorry.
That's horrible.
The Creed frames, by the way, two Creed. The one was Colty stepped on, hit it perfectly to knock me out of there. That's why I was back in 2 seconds. But the other two, you know why? You know what happened? 2 times I brought up YouTube over on my where I used the sound effects. Both times. I was going.
Using up too much assets, dude.
I don't know. But anyways, no music today. The man, oh man, it's Monday. Express, Gary, you were number 1. KC, Kaylee, thank you. Cat lover, yes. Kiernoff and Jamie D, thank you guys so much. And thanks again for a very fun 50K celebration.
Yeah, it was a lot of fun. It was a good time. And if you missed it, you can still go back and watch it and pretend you're there.
Yeah.
But if you want to commemorate the moment properly, make sure you go to our merch store and pick up this amazing limited edition 50K celebration on mugs, stickers, and apparel. Get it while it's still there.
Why is your hand? Can you put your hand up by your
Sure.
face? Let me see your hand.
What's wrong with it?
Just wondering. All right.
Just really give the guy a hard time about the arthritis, would you?
I just,
you know, it is what it is. We got, of course, Mini Chase Monday kicking off at 4:05 today. Make sure you're there for that. There will be, there's actually already been a premiere over on the main channel. Make sure you see that. You're on the caboose, Pamela. And there'll be this case, the very last case. You'll see that on the one coming up, the premiere at 2:30. But there's also like 3 other cases we didn't cover that went on over the weekend as well. So make sure you go by that one. People love to burn stuff up because there's even talk of a Molotov cocktail. I say Molotov cocktail. Creed's favorite drink.
Can you put that back up for just a second?
Molotov cocktail.
Let me put that right up.
Yeah, there it is. See? Got it. It's a hell of a fist. Ladies.
Oh, you're so cute, Colty.
Can't say it. Don't hit me, Daddy.
Yeah, Colty.
Go back and watch some old videos. Wow, that's a big hole in that fist.
Well, yeah,
fill it with something.
Yeah, you put your drinks
in. It's a koozie, right?
Yeah.
Yeah. Nothing but weird looks with that one. Make sure you guys go back, like the video. Like I said, the premiere is coming up. It's for the people who hate me and Creed. So
that's right. But still love the channel.
Yes, but still want to watch stuff, just not us.
Right.
That's coming up in just about 30 minutes. So enjoy that. Till we see you again. Oh God, you're gonna put. Let me see you drink it out of it now. That's what I thought. Stay safe, stay hard, stay tuned. We'll see you on the next one. Bye-bye.
Colt is still up here making noises. You're really testing me today, Colt.
Would you like some water, Colty?
Colty, do you want some water?